I, Michael L., solemnly swear that I will diligently, faithfully, and to the best of my ability execute according to law the office of Mayor for the town of Strathmore, so help me God.
Okay, next up we have Councillor Rocky Blockland.
I, Rocky Blockland, solemnly swear that I will diligently, faithfully, and to the best of my ability execute, according to law, the office of Councillor for the town of Strathmore, so help me God.
Councillor Pat Fuel.
I, Pat Fuel, solemnly swear that I will diligently, faithfully, and to the best of my ability execute, according to law, the office of Councillor for the town of Strathmore, so help me God.
Councillor Denise Peterson.
I, Denise Peterson, solemnly swear that I will diligently, faithfully, and to the best of my ability execute, according to the law, the office of Councillor for the town of Strathmore, so help me God.
Councillor John Rempel.
I, John Rempel, solemnly swear that I will diligently, faithfully, and to the best of my ability execute according to law the office of Councillor for the town of Strathmore, so help me God.
Councillor Bob Sobel.
I, Bob Sobel, solemnly swear that I will diligently, faithfully, and to the best of my ability execute according to law the office of councillor for the town of Strathmore. So help me God.
And Councillor Brad Walls.
I, Brad Walls, solemnly swear that I will diligently, faithfully, and to the best of my ability execute according to law the office of councillor for the town of Strathmore. So help me God.
Good evening, ladies and gentlemen. On behalf of council, thank you very much for attending this ceremony with us. To see you here makes us very proud. I will now call this meeting to order, and I'm actually going to make sure that I'm doing this correctly, so I'm going to be asking Jennifer for a lot of help tonight. The seating arrangement is the first order of business that we have. And as you see the council seated here tonight, won't be the final seating, but it has been agreed on how the council will sit. The first order of business that we're going to conduct is to select a schedule for our deputy mayor. The deputy mayor will sit for 2 terms of 4 months each. And the way that we're going to do this is by drawing the names.
Yeah.
Are you allowed to draw your own name?
Yes. Okay.
Come on,
Don't
Vegas.
draw yours, Pat.
Come on, Vegas. Come on, Vegas. Bob Sobel.
Oh.
Pat Fuel.
Do I draw? I don't draw names. Me.
Brad Walls.
That's right.
Huh, that's me.
So
You're gonna take a guess.
what happens
This
now
might
is
be
this,
John Rempel.
how the
Right.
deputy mayors will be.
Oh, John Rempel.
So it just rolls right over. Okay. Okay, please. They'll read the names out for us in the order that the councillors will sit as deputy mayor.
So from November 2013 to February 2014, we have Councillor Denise Peterson. From March 2014 to June 2014, we have Councillor Bob Sobel. For June 2014 to October 2014, we have Councillor Pat Fuel. From November 2014 to February 2015, we have Councillor Brad Wells. From March 2015 to June 2015, we have Councillor Rocky Blockland. From July 2015 to October 2015, we have Councillor John Rumpel. And from November 2015 to February 2016, we have Councillor Denise Peterson. From March 2016 to June 2016, we have Councillor Bob Sobel. From July 2016 to October 2016, we have Councillor Pat Fuel. From November 2016 to February 2017, we have Councillor Brad Walls. And from March 2017 to June 2017, we have Councillor Rocky Blockland. And then from July 2017 to October 2017, we have Councillor John Rumpel.
Thank you. Do we require a motion on that?
Yes.
Okay.
I'd move that
The deputy
the deputy mayors be
appointed
as
listed.
listed.
All in favor?
Question.
Discussion? Question?
Yeah, question. Through the chair to administration, did we give everybody the opportunity to see whether they're comfortable with where they're picked for the first round? Going back to the previous term, we had a situation where there was the new mayor and the new councillor got picked, and they weren't comfortable with that position. So there was one of the incumbents that took that first term as deputy mayor. And I was just wondering if that is something that we wanted to give the people the opportunity to discuss.
Okay. Denise, did you?
I'm okay with it, Michael.
Okay.
I have lots of faith in you.
And I have lots of faith in you, so. Okay. No further discussion? All in favor? Carried. The next item of business that we will discuss is setting our council meetings for 2014. We've already listed our schedule of council meetings for 2014. The meetings will be every first Wednesday and third Wednesday of the month. There is some minor exceptions, such as if there's a stat holiday, January the 1st being a statutory holiday, our council meeting will be on 8th and the 22nd. During August, historically, council has not sat unless there's been a need. And I think that's the only changes. So if we agree with the schedule as presented, could we have a motion?
Your Worship, I would move that council approve the 2014 meeting schedule as presented.
Discussion? No discussion? All in favor? One further item of business is to appoint members of council to the various committees that the council sits on. And the mayor is ex officio of all of the committees anyways, but Brad Walls will make a motion in regards to our committee members. Oh, sorry, Jennifer.
No problem, Your Worship. So I'm just going to read out the committee names and then the councillors who will be sitting on the committees. Okay. So we have the Strathmore Municipal Library Board and the Marigold Library Board, Councillor Denise Peterson. We have the Woodemza Board, Councillor Rocky Blockland and Councillor Denise Peterson. The Strathmore Happy Gang, we have Councillor John Rumpel. The Wheatland Housing Board, we have Councillor Pat Fuel and Councillor Brad Walls. The Strathmore Handy Bus Association, we have Councillor Rocky Blockland. The Strathmore District Chamber of Commerce, we have Councillor Brad Walls. The Family Centre Advisory Board, we have Mayor Miguel. The Community Futures Wild Rose Board, Councillor Brad Walls. The Communities in Bloom Committee, Councillor Pat Fuel. The Names Advisory Committee, Councillor Brad Walls and Councillor John Rumpel. The Financial Audit Committee, Mayor Mike L., Councillor Brad Walls, and Councillor Denise Peterson. The Strathmore United Way Committee, Councillor Brad Walls. The Calgary Regional Partnership, Mayor Mike L., Councillor Bob Sobel for the transportation part, and Councillor Denise Peterson. The Citizens on Patrol Committee, Councillor Pat Fuel. The Strathmore Wheatland Addictions Team, Councillor Bob Sobel. The Museum Committee, Mayor Mike L. The Downtown Revitalization Committee, Councillor Brad Walls and Councillor Bob Sobel. The Canadian Badlands Committee, Mayor Mike L. The 55 Plus Games Committee, Councillor Bob Sobel. And the Strathmore Youth Club, Councillor Pat Fuel.
Your Worship, I'd move that council appoint members to the committees as read for a one-year term ending October 2014.
Discussion? Seeing no discussion? All in favor? Carried. What's next on our agenda, please?
Your Worship, we have council orientation next up on the agenda. And we have Council Mr. Wildflower here to make a presentation to council.
Okay. The public is welcome to stay for the orientation that the Alberta government lawyer will be giving to council.
Your Worship, just been advised that our lawyer is not here yet. So perhaps we could hold off on this and move on to the next item on our agenda, which is the council procedures.
Page 41.
So in your agenda package, item 3.6, we've included the council procedural bylaw for your review. It's there for you to read. It goes over your proceedings for council meetings. It goes over how you set council meetings, what can be on council meetings, and how you get things onto council meetings. So there's a lot of information there for all of you to read and take in. I'm taking questions at this time. I'm not going to go over it line by line with you, but maybe if you have a read with it and if you have any questions, certainly ask administration.
This is the same procedural policy that was in place for last council.
This policy actually came into effect May 1st of this past year. It's similar to the policy that was with council previously. There have been some changes, though.
Do you need a motion on that?
That's just for council's information, Your Worship.
Thank you.
Okay. Okay, so the next item on the agenda is we have some housekeeping items to take care of. There's a number of them there that we've listed. The first is Alberta Urban Municipalities Association Annual Conference. Every year, the AUMA holds an annual conference. A lot of municipalities throughout Alberta attend. This year it's in Calgary from November 20th to 22nd. Administration has booked accommodations for all of council because the rooms sell out really fast. So we book them at the beginning of the year for everyone. The rooms are non-refundable, so we encourage council to attend if they can. So I need you to think about if you plan on attending. I need to know by November 1st, as that is the early bird registration deadline. And also, sorry, in front of you, you have a package from AUMA in regards to the upcoming conference. It's very valuable for first-time council members to attend, as there's a lot of sessions on being a member of council and your roles and such with that role. Is there any questions about the AUMA?
Is there a training session for new councillors?
There is, yes.
And what day is that held?
I have it here. So that is actually on November 19th. It's a pre-convention session. It's the council orientation and contract issues. There's actually a number of sessions on that day. So that's now that I've been elected and the role of the municipal elected official. So that's November 19th.
So as a new member of council, if I'm planning on attending, I should notify you also because it would require.
Correct. I would have to register you for the conference.
Oh, sorry, Rocky.
Through the chair to Jennifer, and administration, November 20th is also a scheduled council meeting. How do we do this?
So luckily the conference is in Calgary this year. If I look at the schedule on Wednesday, the resolutions end at 4 p.m. that day, so there would be sufficient time to come back for the council meeting. The only two things that evening are the receptions with municipal affairs. Sorry. So that.
So I guess we will have to take a look at our schedule and see whether or not we will change our council meeting night.
That's at council's discretion.
Okay. That decision does not have to be made at this point in time?
No.
Okay, good, thank you. We'll discuss that later then.
Your Worship, I've just been advised that there is a public hearing on November 20th, so we would need to hold a council meeting that evening. So we would need a quorum for council meeting that night. Or we could reschedule it now so we could re-advertise the public hearing and the council meeting.
Pardon me?
Would you like any more on AUMA? No? Okay.
No.
Okay, so the next thing on our list is council workshop. So our fall workshop is coming up. It's been scheduled for November 16th. That is a Saturday. Just a little background, council takes a day or two, either every spring or fall. Spring workshop is to deal with other issues besides budget, and fall workshop is to deal with budget. So it's a fairly important workshop coming up. We have it scheduled right now for November 16th, and administration is preparing that as we speak.
Thank you.
Third item, council expenses. So there are expense forms for council for things like attending the AUMA conference, mileage, things like that. Administration has those forms for you, and we'll give them to you at the end of the evening. The fourth is supplies. So as elected officials, you'll obviously need some things to carry out business. We have phones for all members. So if you've been newly appointed, we have a phone for you after the meeting. Also, just let us know other things that you would need, such as portfolios, things like that. The other thing we would like to ask council, maybe for your consideration and comment, not necessarily tonight, but maybe in the future, is what would you prefer for, would you prefer laptops? There's different options, I guess, such as iPads, things like that. So we just would like council to think about what they would like and let us know, and we can move forward with that. We also have keys, business cards, things like that that we'll have tonight. We'll have proofs for you to proof your business card, and yeah, I think that's it. If you need anything, just let administration know. Also, with that, we have a sign-out procedure for supplies. So anything you sign out, you'll be required to sign a sign-out form, so that we know what you all have. The last thing that we want to talk about, I guess, is Citizen of the Month, and this is for council's discussion. And typically, I guess the past 3 years, council has appointed, or I guess, a Citizen of the Month each month, and I don't know if there's been some discussion about continuing with that or not. So that's just something we wanted to bring to council for them to discuss whether or not they'd like to continue with it.
So our lawyer is here now.
Okay.
So Joanne, if you'll come to the hot seat.
I don't have a checklist.
It wouldn't take long to check. My papers up. Why do they want to pay me with a check? That's your job. Sorry, that's your job.
Get on it, or I'm not giving you the chair back. That's right, or I'm not giving you this chair back. All right. Is on, I'm good to go?
Yes.
All right. Now, I am notoriously bad at slides, however. So what my goal is tonight is to walk everyone through council roles and responsibilities. I'm sure this is old territory for the returning councillors and perhaps new territory for new councillors. So first off, does everyone have their new, fresh, crisp copy of the MGA?
Yes, I do, but not here.
Okay. Well, the MGA is over 400 pages long. You'd be delighted to know that we're not going through every single page of the Act tonight. I'm really going to hit the big parts, and I prepared materials that I think have been distributed to everybody that will hopefully be a bit of a touchstone if you think, you know, I know she talked about X. Where do I go in the Act to find that? And I tried in my index to give, and I put in this, I tried to put in the section numbers, so if you did need just a quick reference that you could go directly to the section numbers. And also, this is your workshop. This is, if you've got questions, you want points of discussion, please don't hesitate just to ask questions. Otherwise, it can get very dull listening to Joanne talk. So where do we start? And we really do, I guess, we start at the beginning, as they say, to talk about what is the purpose and power of a municipality. And what's important about Section 3, because where councils get challenged predominantly is if you start to go outside of the jurisdiction as prescribed in the Municipal Government Act or another piece of legislation. So this is really the mother and apple pie provisions. So the purpose of the municipality: provide good government, provide services, or other things, in the opinion of council, are necessary for all or part of the municipality, develop and maintain safe and viable communities. This is drafted extremely broadly, I think, for the purpose of giving you a lot of discretion in how you conduct your business. And Section 7 comes into play when I get questions from municipalities. I've got about 3 opinions right now talking about Section 7, because I've got municipalities wanting to do some things, dealing with medical marijuana facilities, wanting to do things with some cyberbullying bylaws, a lot of potential jurisdictional questions. So it's important as a councillor to understand the scope of Section 7, because only council can pass bylaws. And so if you do have a concern and you're interested to know if this is something within your parameters to deal with, Section 7's the place to go. And again, drafted broadly. Safety, health, welfare, and protection of people, protection of property, people, activities, and things in or near a public place or place is open to the public. There's a host of other items in Section 7, and I think the Strathmore's got bylaws dealing with each one of these issues. One thing to keep in mind too is Section 8. So Section 7 gives you the broad shopping list of what your bylaws can deal with. What Section 8 says is how you can deal with it within your bylaws. So obviously regulation or prohibiting. The other important aspect, because one of the challenges against some bylaws is that, well, this is illegal because it's discriminatory. It may grant some rights to some and not all. It deals with things differently. Well, this is where a municipality goes to Section 8 and say, well, the legislature has specifically allowed us to deal with things in different ways. We can divide things into different classes and deal with each one of those classes in different ways. Now, one thing to keep in mind, even though we're talking about these broad provisions in Sections 7 and 8, these broad provisions don't override the specific provisions in the Act, predominantly when we're talking about planning and development and when we're talking about taxation. And we're going to talk more, we're going to get more into this, the parameters when we're talking about off-site levy bylaws. I'm sure some of you are aware of the Prairie Communities and Town of Okotoks decision. It was about off-site levy bylaws where the town of Okotoks was relying on their natural person powers because a municipality has natural person powers. So unless you are prohibited by a statute or a statute mandates how a municipality is to do something, you can deal with things like any other corporation can. And so Okotoks had relied on natural person powers to enter into agreements with developers to pay for a host of things that exceeded the Part 17 parameters, predominantly soft services. And the Court of Appeal was quite clear that even though you do have these broad powers, Sections 6, 7, and 8 in the Municipal Government Act, those do not extend to Part 17 matters, and they don't extend to taxation. So basically anything that is specifically prescribed by the statute, especially when it talks about individual rights and property rights, that is something where you have to be very mindful of the parameters prescribed by the Act. One thing to also keep in mind under Section 8 is that the legislature specifically allowed a municipality to set fees which may be in the nature of a reasonable tax for the activity authorized. There's a Supreme Court of Canada decision where fees were challenged on the basis that they constituted a tax as opposed to the actual administrative cost of administrating this program. And this is where the Alberta legislature stepped in and said, we are going to specifically authorize municipalities to set fees which may be in the nature of a reasonable tax. There's still some parameters, but you do have some ability. Some cost recovery fees that I can think of are the cost recovery, the fees and charges that you may charge developers that would translate back into the cost of your administration processing these development applications. And provide for an appeal and specify the appeal body. The Act is clear that Council, if you are named as the appeal body within the Act, for example under 545 appeal, you must hear the appeal unless you have by bylaw prescribed for another appeal body to hear that appeal. And Section 6 is natural person powers. So we've got two aspects of duties and responsibilities. One is as council as a whole, and the other one will be with respect to individual councillors. But we'll speak about the duties and responsibilities of council as a whole. So council sits as the policymaker up here. And when I try to describe people who do not know anything about municipal law and they ask me, well, we don't really understand where council sits and the CAO, we don't really understand the dynamics. It's like a big hourglass. So council's up here, and this is where you have policy and you set bylaws. Your CAO is your only employee, and he is the administrative head, and then you have staff. And that's how information flows. Council gives direction down through the CAO, who's then responsible to ensure that your policies and directions are carried out. And then that's what staff does, but then also that information flows back up through the CAO to council. We'll talk a little bit more about that dynamic. So council, again, your role as a policymaker, you're not there to get involved into operational decisions. You need to let staff handle operational matters. Obviously, if you've got questions, that's absolutely fair ball, and those are questions are directed to your CAO, or if he tells you these questions will be directed to another employee, that will be where the questions are directed. But keep in mind that because you're a policymaker, you're not in an operational role. It is inappropriate for council to be dealing directly with staff on operational matters unless this is something that the CAO has authorized and said this is the appropriate party to deal with. And we'll talk a little bit more about why that's important. So, develop and evaluate the policies and programs. Ensure that the powers, duties, and functions of the municipality are appropriately carried out, and that, of course, is through your CAO. And the MGA, Municipal Government Act, and some other enactments specifically specify that council must do certain things. If an act doesn't say the council must do or the CAO must do, then it's really up to the municipality about what body carries out that function. But where an act does say that council may or council shall, only council can do that activity. Now this is important. Section 201 sub 2. So you are statutorily prohibited from exercising a power or function or exercising a duty that is by the MGA, another enactment, or a bylaw. So it would typically be your CAO bylaw, be the big one, specifically assigned to the CAO. So again, this is that big hard line. And it's not a soft line, it's not a blurred line, to quote Robin Thicke. It is a hard line between policy and operations. And what's important here is, and we're going to talk about your statutory liability protection under Section 535 of the Act. Now, Section 535 provides that if a councillor, well, and employees and other officers, are acting in good faith and performing or intending to perform their duties, powers, and functions, that you're not liable for any damages that may be caused by anything said, done, or not said or done. In my opinion, if council starts getting involved in operational matters, council starts getting involved in things like hiring, firing decisions, anything that the CAO is responsible for, this, and there's damages that result, this is where a councillor can be personally liable, because you are no longer acting in good faith. You're specifically acting contrary to the Act, specifically acting contrary to Section 201 sub 2, and you're specifically acting outside of your assigned duties and powers. And I'm going to give you an example, and I don't know if any of you know Larry Konchak. He was a former reeve of the MD of Rockview many years ago. And there was a lawsuit by Dale Clark. Dale Clark was a former CAO. And this was back in the early 90s, 1995, 1996. And he was a CAO and he was terminated for cause by the municipality. Well, he sued the municipality for wrongful termination. And he named Larry Konchak personally. Larry Konchak was a reeve at the time. And he alleged that Mr. Konchak utilized his office and position as reeve to push council to terminate him for cause. He alleged that Mr. Konchak had a vendetta and he was basically on a witch hunt. So that was a very long trial. It was about a 3-week trial, and we had counselors there from 3 different councils. We pushed for a non-suit, and the justice that heard it said, well, there might be something to this, because under Section 535, if I'm satisfied that Mr. Konchak did utilize his position of reeve to try and push council for his own personal reasons to terminate the CAO, there might be something to that. Now, at the end of the day, Mr. Konchak was fully exonerated. He had done nothing wrong. Mr. Clark had been properly terminated for cause, and the reeve had not overstepped his bounds at all. However, what the justice said about what he would have done if he had found that somebody was effectively on a witch hunt and looking to push a termination for his own personal agenda, Mr. Konchak would have been personally liable for damages. So that's something to keep in mind. I have had other councils, and not in this municipality, but other councils, where there have been councillors that have been out to get senior members of administration, and it has resulted in fairly high settlement numbers. So be mindful. The other thing to keep in mind is enforcement issues. Again, not in this municipality, but I've had other municipalities where I've had councillors talking to safety codes officers, telling them to back off, telling them to give the guy a break. That's safety codes. That's public safety matters. If a councillor got involved with trying to influence a safety codes officer and how he or she was carrying out his or her duties under the Safety Codes Act and there was damage or loss, that would be an abuse of office type lawsuit against the councillor personally. And it would be the same thing with any sort of councillor or even council potentially getting involved again in these operational decisions. Oh, I can tell you one other short story. Again, and this was in the early 90s. The early 90s were kind of an interesting time, apparently. But it was an enforcement matter. And it was out in a rural municipality. And we had a gentleman who was in the process of building a second residence. And he had no permits in place, not a one. He didn't even have proper zoning. And he had spent quite a bit of money. And so we had the Reeve and another councillor, and I think those gentlemen had the best intentions at heart, but without staff involvement, they went out to visit this guy to try and work things out, sort things out, make everything go away. So they said that they just told him what the proper process was. They said that approvals would not be a problem, this shouldn't be a big deal, just not a problem. Well, it was a big problem because, of course, there were only 2 voices on council, and he didn't get his rezoning, which meant he had to tear down his second house and move it, and he suffered significant loss in doing this because at the point in time where they went and talked to him, he had the foundation poured, but he actually got the package and he got everything constructed subsequent to their conversation. That never ended up going to trial, but of course no one took a note. There wasn't a hand scratch on a napkin to talk about what actually was said. So it was landowner versus the councillor in the Reeve, who knows what was said. So that actually got settled as well. But that's also just something that you could be mindful in the kind of discussions that you have with contractors, developers, anybody. You're only one voice in council. Be very cautious about telling anybody that something's going to happen when it's dependent on a vote, because you've got no control over that vote. And because you are a councillor, you're always going to wear that hat. And it doesn't matter if you are in co-op buying milk, you are always wearing your councillor hat. And people put a greater weight on what you say, even if it's a casual conversation and it's in passing. And this can form a negligent misrepresentation lawsuit, which is what happened with the Reeve and those 2 councillors. I said they were councillors. I trusted them. I relied on what they said. You can argue till you're blue in the face whether or not that was reasonable, but just be mindful. So something that council can never delegate is the power to pass a bylaw, and of course anything to do with employment of your CAO. Budgets are fully within council's authorization. You can't delegate that. Anything to do with taxes, you can't delegate. And again, as I mentioned earlier, where you are appointed as the appeal hearing body, you cannot delegate it unless it's to a council committee and authorized by bylaw. And also you have to provide your CAO with an annual written performance evaluation. And the reason for that didn't used to be in the Act, but in order to facilitate regular communication, the legislature said, well, at least you folks have to talk once a year. So, and I'm sure you talk much more than that. So, individual councillors. So that was council as a whole responsibilities. These are, now we're going to move into councillor duties and responsibilities. These are for individual councillors. First is to consider and promote the welfare and interests of the municipality as a whole. Still important, I think, obviously for the urbans, very important, I find in my roles where I have got councillors that are voted into districts. I have to say, yes, you're the councillor representing that district, but when you come to the table, you are looking at the best interests of the entire municipality. And same thing, especially with my urban municipalities, I may have councillors who came in very strong because they represent the seniors' interests or whatever, or the business community's interests. But when you're sitting as council, you're looking at the best interests of the municipality as a whole. And to bring to council's attention anything that would promote the welfare and interests of the municipality, to participate generally in developing and evaluating policies and programs of the municipality, To participate in council meetings of council committees and other bodies. In fact, missing too many meetings, and we're going to talk about that under disqualification, can be the reason for being disqualified is by missing too many meetings. Because obviously you're elected to represent, and the only way you can carry out that obligation is by coming to the meetings. So I don't think I've been doing this since 1995, and I don't actually ever recall having a councillor come anywhere close to being disqualified for that reason. And again, as we talked about, to obtain information about the operation and administration of the municipality from the CAO or his or her designate. And again, that's a statutory direction that's where you get your information from with respect to operational matters.
Your Worship, just through the chair to Joanne. So you're talking about there, it says, and other bodies that the councillors pointed to. So if I attend no committee meetings, I can be booted off council.
Oh, no. That's a very excellent question. Under 174, I do believe it is just council meetings. I think you might get replaced on your committee. But just let me know.
Not that I'm trying to get out of work, Your Worship, or nothing, but just wondering.
Just bear with me. Yes. So under section 174, sub 1, sub D, a reason for disqualification is a councillor is absent from all regular council meetings held during any period of 8 consecutive weeks, starting with the date that the first meeting is missed, unless council passes a resolution giving you an exemption. So it only applies to regular council meetings. Okay?
Thank you.
If you're hospitalized or something like that, does that?
Council will pass a resolution that just authorizes you, and that's happened quite regularly. I've even had some councillors that have ended up on a very special anniversary scooting away for a little while on a big trip, and they even got council's blessing to miss those meetings. So councils tend to be pretty reasonable if there's circumstances. So another councillor responsibility, and this is statutory mandated, to keep in confidence matters that are discussed in private at a council or council committee meeting until those matters are discussed at a meeting held in public. Now we're going to talk briefly about the Freedom of Information Protection and Privacy Act a little bit later. But this is important. If a councillor breaches confidence, and that results in damages or loss either to another party or to the municipality, you could be held personally liable for that. And I had a councillor in another municipality that got a little carried away with his blog and ended up spilling the beans about their CAO's employment situation. So there was a FOIP investigation, and that individual could have been liable. So we're also going to talk a little bit about being careful about social media. And I don't know how many of you have websites or blogs, but I know that it's popular, and I've got councillors all over the place that have these. Always have sober second thought before you hit send or post, because once that cat's out of the bag, it's out, and it can result in all kinds of complications. And again, to the extent that councillors, you're given any specific duties or functions prescribed by an act, that's also within your parameter of must do. And of course, your oath of office, if you've been sworn in, and this also comes into the Code of Ethics, and it also comes into a potential breach of your duties as an officer of a municipality if you breach confidence and if you act contrary to your positive statutory obligations under the Act. Now, one thing with respect to the chief elected official, I just find sometimes I need to clarify, because it used to be the case way back before I practiced, that the mayor or the reeve only voted if there was a tie, for example. That's no longer the case and hasn't been for quite some time. But it was funny because I just read in a newspaper in the last week where someone said that. I'm thinking, are you kidding? No, that hasn't been the case for years. So the mayor or the reeve, the chief elected official, has all the same duties and responsibility as any other councillor. There's one voice, one vote for the mayor, or with my rules with the reeve. Really, the chief elected official is the spokesperson for the municipality. That's one thing. I thought Nenshi did a heck of a job during the flood, but holy crap, he had a whole council behind him making decisions, and he had all this administration and all this staff. And I thought the mayor's getting all these kudos and no one's recognizing everything else is behind him. And so I think that's something to be mindful of, is the mayor has a very public role and typically will be appointed to be the spokesperson when you're dealing with problems in other municipalities, but the mayor is also really just another councillor. One thing that a chief elected official is a de facto member of a council committee, except for any board or committee under Part 17 for planning and development. Then the mayor must be appointed in his personal name. Otherwise, de facto member of all other committees unless council directs otherwise. Now your CAO, and this is something that, also for any new councillors, it's important, I think, to review these sections so you really grasp the importance of the Chief Administrative Officer. CAO is your only employee. And the CAO has got a combination of duties. Some are prescribed in the Municipal Government Act, sections 207 and 208. You should be familiar with if your CAO has an employment contract. No. Okay, some do. I will say make sure you know what that says. You will have a CAO bylaw. Make sure that you have reviewed that so you also understand what additional powers and duties may have been delegated by council to the CAO in that CAO bylaw. Because remember, as soon as that's delegated to the CAO, hands off for council. So we've talked about it. So your CAO's administrative head. Your CAO is who is responsible to ensure that the policies and programs are implemented, and is your source of information. If you've got questions, that's who you direct your questions to. So again, I'm not going to go through all the shopping list under section 208, but it's quite a list with respect to all the administrative functions that the CAO is responsible for. And the CAO can delegate a lot of these duties, but at the end of the day, that's where the buck stops with your operational matter. So under section, which time do I have, Dwight?
Another hour.
Okay, good.
What?
They're like, this is painful. Did she bring a scotch? What's going on? Okay. So under valid action, council can only act by bylaw or resolution. And sometimes it's, oh, why did I not put that in here? Okay, I'm going to explain to you what bylaws and resolutions are. Now, one thing to keep in mind, sometimes the Act says that council may, by bylaw, do something. So, for example, an area structure plan. Part 17 says that council may, by bylaw, adopt an area structure plan. What that means is you don't have to adopt an area structure plan, but if you do decide to, you must do it by bylaw. So whenever you see the phrase may by bylaw, it means that if you do that thing, you can only do it by bylaw. So the difference between a bylaw and a resolution is bylaws typically are there to regulate an activity. They're intended to have a long-term and broad-reaching effect. There's often penalties imposed for a breach of a bylaw. A resolution is a more immediate direction. So for an example, council may pass a resolution directing administration to sign a contract, to draft a letter to another government department. It's something very immediate and defined. Oh, the other problem, of course, is whenever you're in camera, the only resolution that you can pass is to go back into a public meeting. So even if you have in-camera discussions that require an action or direction of council, you've got to go back into the public meeting and pass that appropriate resolution, which may have to be sensitively drafted depending on the nature of those in-camera discussions. So voting. you're in attendance at a meeting, you are required to vote on any matter put to a vote unless you're permitted or required to abstain from voting. And failure to vote may result in disqualification. Because again, there had been some cases some years ago where there were some councillors that on hot topics just chose to take a big pass on that question. And of course that kind of defeats democracy, is avoiding the tough issues. So when must you abstain? There's really only 2 times when councillors must abstain. If you have a pecuniary interest in a matter, which we're going to talk about, you must abstain. And if you are absent from all of a public hearing that was held with respect to a bylaw or a resolution, you must abstain. I have a situation right now in a municipality, the timing was horrible, but they went through their full-day public hearing on a rezoning, but now second and third reading are after the election, and all of a sudden we don't have quorum because I've got councillors there that weren't there at the public hearings, and now they have to redo the entire thing. Sometimes that happens. The only time that you may abstain from voting is where you are absent from part of the public hearing. And it may be the case that you think, you know, I really needed to be there and hear things. I just don't feel like I got enough information. That's your decision. Or you may say, you know what, I've had the opportunity to read the materials, I've had the opportunity to read the draft minutes. You know, I think I feel comfortable, I've got enough information. But again, whenever we're talking about whether or not a councillor abstains from voting, that is the individual councillor's decision to make. It's your call. Rightly or wrongly, it's your call. Council may weigh in and give some feedback, but it's not council's decision. It's that individual councillor's decision. Meetings, I'm not going to spend a lot of time on it. I mean, administration knows about meetings and what's required. Maybe the only thing that might be particular of interest might be the special meetings. So of course you've got your regular council meetings that are on your set days, but you also can have special meetings. So the mayor, there's one good power of a mayor, can call a special meeting, frankly, whenever he thinks that that's appropriate to do so. But also council, if council, a majority of council puts in a written request to have a special meeting and specifies the purpose of that meeting, then the mayor must call a special meeting within 14 days of receipt of that request. And that's section 194. So with a special meeting, and sometimes it's with fairly emergent items, it does mandate that 24 hours written notice in writing must be given to councillors and the public. However, that notice requirement can be waived if 2/3, and this is of the whole council, not just all the councillors present at the special meeting, but of the whole council agrees in writing before the beginning of the meeting to waive the notice. And again, that often will happen in emergencies, that kind of thing. So under section 197, all your meetings must be held in public with some specific exceptions. One of the exceptions, and we're going to talk more about FOIP, if the matter to be discussed is within the exceptions to disclosure in Division 2, Part 1 of the Freedom of Information Protection and Privacy Act. The Act has a breakdown of mandatory exceptions to disclosure, which are basically confidential business information, personal information, that kind of thing. But then they have a whole slew of discretionary exceptions to disclosure. Draft bylaws, draft budgets. If you are having intermunicipal discussions, if you're having dialogue with the province, there are all sorts of things that you may opt to handle in camera. Obviously, again, if you're going to be passing a resolution, giving direction on how to handle these matters, that has to be done in public. One thing also to keep in mind, if you are acting as MPC, subdivision authority, development authority, or if you're sitting on the SDAV under Part 17, you have to hold the hearing in public. But then Section 197 specifically allows those planning and development bodies to both deliberate and make the decision in camera. And the rationale for that is really to allow there to be extremely frank discussion without the members of these bodies being swayed by media or public opinion. It's not a popularity contest when it comes to planning development. It is what is proper planning and development decision making. And sometimes that is more easily achieved in camera. It doesn't have to be in camera, but it's an option. And council meetings, council committee meetings can be conducted through electronic means. I mean, we've done it through video conferencing, teleconferencing, there's Skype available these days. Section 199 has some specific parameters about how that can be done. But I've had counselors that are in Florida or they're overseas or whatever, but they want to be present. So we bring them in somehow. And it works great, and yes.
Well, I just want to know, you're not talking about just doing a tweet or email or something like that as an electronic. You're talking an actual meeting?
Oh yeah, if there's a council meeting and you've got one or two or even the entire council somewhere else, you can be brought together. But again, it's got to facilitate people being able to hear each other and so participate in the discussion.
Okay.
You don't have to be seen, so it can be done by teleconference. But yeah, no, tweeting and emailing won't cut it.
Good.
So, before we move into pecuniary interest, do we have any lingering questions or comments from that part? Okay. So pecuniary interest. Pecuniary interest provisions are something that they're one of the most important aspects of the Act, because breach of pecuniary interest is a very easy way to find yourself out of a counselor job. And again, we're going to walk through this, but at the end of the day, the decision of whether or not you feel that you've got a pecuniary interest in a matter is your decision. You may want to go get independent legal advice, and I've had that happen, because when a municipality contacts me as a lawyer for the municipality, I take a very conservative approach. And if there's a gray area, I'm going to err on the side of caution, because I view my job as keeping all the elected officials in their seats. I have other counselors, and I absolutely respect the right to do that, to say, well, I think you're being a bit of a ninny with that advice, so I'm going to go make my own decision and get my own lawyer, and if someone challenges me, it'll be my problem. And that's fair ball. But, yeah, pecuniary interest, and we're also going to talk about common law bias. So these are the most relevant provisions. So and when we talk about pecuniary interest, the other common term is conflict of interest. And really, my rule generally is if you've got a red flag in your gut, you just think, I'm not sure if this is right, follow up. And I think most of the time when I've had the phone call from a CAO, and sometimes I've had the phone call from a counselor directly, they're right. Their guts told them that something's not right on this situation, and unless I can find them an exemption under section 170 sub 3, is usually the safer route is to declare. Because the other thing, not only, following the spirit and the letter of the law under the Municipal Government Act, but it's also about perception and how the public is perceiving a counselor. Because there's nothing that I think erodes confidence in elected officials is for the public to question of whether or not they're coming clean to the council table. And just to avoid that, if you think there might be a perception here that I'm offside, that might be enough. I mean, you don't want to avoid the hot topics because you might have some involvement if it's not fall within the pecuniary interest, but you do have to be mindful. And the other thing about pecuniary interest, and we're going to talk about some of the exceptions, but it's not about the dollar value. So there's no threshold monetary amount. It's more about connection. It's more about we want to avoid a situation where a counselor is perceived as either going for something or taking all kinds of measures to distance themselves from a particular position to avoid being viewed as having a conflict of interest. You just want to come there cleanly without any outside influencing factors. So the other issue with pecuniary interest is it's the could test. It's not would, it's could. Could the matter monetarily affect the counselor to the extent that a reasonable elector, apprised of all the circumstances, would be more likely than not to regard the counselor's private interests as likely to influence their public action or decisions on the matter? So again, it's could, and that also is going to apply to your family as well, or and then your employer. So again, Section 170, counselor has a pecuniary interest if the matter could affect the counselor or the employer of the counselor, or the counselor knows or should know that the matter could monetarily affect the counselor's family. I need to make sure that I'm not skipping ahead, but I also want to make sure I didn't miss the slide here. Okay, so when we talk about whether a person is monetarily affected, it's if that person is directly affected, or if the person is a shareholder, director, or officer of a corporation that could be affected, or if you're involved with a distributing corporation where you're beneficially owning voting shares of at least 10%. So, you're wondering about Section 169, and 169 is kind of an interesting section. Well, I guess interesting to me. A bit of a geek that way. So, spouse or adult interdependent partner, children, and it doesn't matter how old your kids are or how much you talk to them, they're yours, and if you have anything that could monetarily affect them, you're caught. And you're also caught if it could monetarily impact your parents or your in-laws. You know what it doesn't catch? Your siblings, which is an interesting issue, which we're going to catch with common law bias. Because if you have a brother or a sister that comes here for rezoning, you can't hear that because of common law bias. So we're going to talk about that. But spouse, the good news is, even though it's going to catch your husband or wife, it's not going to include your partner who's living separate and apart if you have got a written separation agreement or if your support obligations to family property have been dealt with by court order. So there's some practical exceptions to that definition. Yeah, that was on the entire next slide. Now, one thing we also have to be mindful of is that that's a starting base with respect to pecuniary interests. Could this have a monetary impact? The next thing you always will go to is Section 170 sub 3, because that's where the exceptions are. But it's interesting the way that Section 170 sub 3 is drafted. It says that a counselor does not have a pecuniary interest by reason only of any interest. So there's that limiting factor, by reason only of. So if you come within some of these exceptions that we're going to talk about, but you have some other connection, just because you fit in one aspect that's protected under Section 170 sub 3 may not relieve your pecuniary interest provision if you've got another connection with the matter, if that makes sense. So some of the big ones, so 170 sub 3 is a fairly healthy list. Maybe you have the act in front of you to be able to see the healthy list. But some of the big ones, you're not going to have a pecuniary interest by reason only of an interest that you may have as an electric taxpayer or utility customer, obviously. That's another good one. Counselors are also not seem to have pecuniary interest when they're talking about your honorariums or remuneration as sitting as counselors. Now, while your employer is caught your personal employer is caught by pecuniary interest provisions, the employer of your family members is not caught unless that employer is the municipality. So again, only worry about it if you've got a family member who's looking for the county. If you are a member or director of a nonprofit organization, you're not going to be caught by pecuniary interest. That's always something. I don't know if we've got anybody here who is a fire chief involved in the fire. No, I've got some fire chiefs that do sit as counselors, and they also fit under an exemption. One of the big ones is community of interest. And I'm going to read you the section because this is probably the one that I get most of the questions about. So again, you're not going to have a pecuniary interest by reason only of an interest that's held in common with the majority of electors of the municipality, or if the matter affects only part of the municipality with the majority of electors in that part. This is a big, huge gray area. Because this interest, this community interest, has to be the same in kind. So for example, if you, let's say we're talking about rezoning and of a parcel, and you happen to live across the road, well, it may impact your property values. So you might argue, well, that's a community of interest because this is impacting an area, and everyone's property values may be impacted by this proposed development. The potential argument is, well, is your interest the same in kind as the person a block away? If you're directly across the road, would you not have a more significant impact to your property development? And my general rule, which may or may not be shared with others, but this will be the advice that I will give, is if you are in the notification, specific landowner notification area for a development, you may not fit within community of interest provisions, because by having that specific notification area, there's a recognition in the land use bylaw or in the Municipal Government Act that your interests are being particularly impacted by this proposed development. And again, because of the wording, it has to be the majority. You have to share it in kind with the majority. The other thing is that I've had counselors who might be they might be looking to subdivide. They might have their property up for sale. I say that is also changing the nature of your interest. Another one is you're not going to have an interest that's so remote or insignificant that it cannot reasonably be regarded as likely to influence the counselor. I will use a real life example of this. I had a counselor who had a son who operated a gravel company. And she asked me once upon a time, years and years ago, if she would have a pecuniary interest hearing a rezoning matter because it was going to facilitate development and her son provides gravel for roads, blah, 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 blah. Well, we're at rezoning. There's a lot to happen before that gets off the ground. Her son had no history of doing work for this developer, and the developer would put this all out to tender anyway. And he hadn't made any firm arrangements, so that was going to be remote. But arguably, if her son's company was the preferred gravel supplier to that developer, maybe we would have crossed the line and moved on. So all of these things are very fact specific. So if you've got that kind of a question, whether you fit within one of those examples, that's a question to ask away. And that may be something that you get legal advice on, because it's going to be very specific on the facts. And business bylaws. If you own a business, you have a business interest, you're not going to be viewed as having a conflict of interest because you are dealing with general business bylaws. However, if the bylaw deals specifically with your business or that of your family, you're going to have a conflict. There's some water. That's great. So there are sometimes it comes into a situation where there is a challenge and the justice does find that a counselor technically is disqualified. One thing to keep in mind is Section 177. It's inadvertence or genuine error of judgment. In very limited circumstances, a justice can find that, the counselor was offside and they are actually disqualified, but I'm going to allow them to remain in their seat because I found that this was due purely to inadvertence or genuine error of judgment. Failing to vote, so that would be thank you. So that's why and again, you're acting in good faith and not just, trying to really stretch the argument with respect to pecuniary interest. But if you play it on the safe side and you fail to vote and someone decides to take a run at you, and the judge would look at that, I can't imagine a judge ever disqualifying a counselor in a matter of declaring pecuniary interest to say, well, you know, when you dissect all the facts, I think you probably would have come within the exception. There's no way a justice is going to disqualify a counselor for that. Entry into legal agreements and use of information obtained through being on counsel to gain pecuniary benefits. And again, if you are on counsel and you have, again, through your position as a counselor, you're privy to certain information, some of that's confidential information. And if you utilize that information for your own personal benefit, big trouble. Yeah. Not only can you be disqualified, but you can also be ordered to account for your profits and pay it all back. However, sometimes mistakes are made. And again, if someone took a run at you and the justice looked at all the facts and said, that was not intentional at all, I think the counselor was acting in good faith, and this was just a mistake, they got discretion under section 177. Slides are to be delayed. So pecuniary interest is the statutory provision that the Municipal Government Act says that you cannot vote on or discuss matters where you have a pecuniary interest. But we have this whole other body of common law bias, which is all common law. So that's all judge-created law. Pecuniary interest can get you disqualified, but the council's decisions are protected. So even if you participated inappropriately with pecuniary interest, you could get punted as a counselor, but that decision that council reached is actually protected. Common law bias is different, because under common law bias, it will apply in a public hearing context. So rezoning, ASPs, anything where there's a public hearing, if you're sitting on STAB, for example. And if you've got common law bias, the decision can be overturned and sent back. But you, unless again this involves pecuniary interest, you're not at risk of being disqualified as a counselor because you participate in something with a bias. Now, common law bias is very broad, and it includes pecuniary interest, but only the MGA has codified it in relation to pecuniary interest. But it also extends to relationships. So again, this would involve the sibling, because remember I told you the definition of family under 169 doesn't involve a sibling. It will catch you, however, in a public hearing context because of that relationship. You know what else it catches? It has caught people, I kid you not, they had joint restraining orders against each other. I had a counselor and a ratepayer with a history of family feud. There is no way that counselor could ever sit on anything that individual brought forward because there's no way there could have been a fair hearing. But it would involve if you're very close friends. I mean, and this is also, it can be a bit of a gray area where counselors are out and about. I mean, they're social people, and they have coffee with people, and they have relationships. That's why you're on council. But there is a difference between somebody that you meet for coffee from time to time versus the person that comes and shares Thanksgiving dinner with you, shares Christmas dinner with you. You have that kind of a close relationship. So be mindful of those kind of relationships. The other thing to be careful of, and there's a few recent 2013 cases that I've pulled, and it's in the SDAB context, but it involves counselors. And even though this is in an SDAB context, it would apply to your other public hearings that you would sit at as a counselor. And this is two separate cases. One is out of Parkland and one is out of Thornhill. And they're both 2013. In the Thornhill matter, it involved a gravel pit application. And we had a counselor who was very vocal on the website and Facebook and took out media ads. No more gravel pits. Why are we voting for gravel pits? This is a horrible idea. Oh, horrible, horrible gravel pits. And was very vocal. Well, wouldn't you know, STAB, there's a development appeal for a gravel pit. And the counselor participated. Well, not only was leave granted, the appeal was granted. Court of Appeal said, you know, clearly there was a common law bias. This counselor had taken a strong position against this very development, not just generally with gravel pits generally, but this very development. So you could not hear this thing fairly. And so it was sent back to STAB with the direction of this counselor not sit. I had another situation where, and went up to the Court of Appeal, but we agreed to deal with it through a consent order, where I had a counselor who was a realtor. And he had a lot of prior involvement with this particular development matter. He acted as a realtor when the parties bought the property. And then after, he kind of guided them along through the development process and told them what to do. And then, holy crap, he sat on the SDAB hearing and voted for it. So again, this was relationship and prior involvement. So we dealt with that through a nice, tidy little consent order and had it directed to be heard without that individual sitting. So you have to be careful. I've also had, especially in election years, where I've had counselors that have been involved with community groups prior to being a counselor. And they have had very strong positions about certain types of development. And they have come to council meetings and spoke very strongly about their position. And then they're sitting as a counselor, which is great, but they had to be mindful of that prior level of involvement, taking a position on that kind of development, because when it comes to council dealing with it, they had to recuse themselves, which was kind of defeating the point of why they got elected. But anyway. Obtaining independent information. Be very, very cautious when you know that there is a live application that's coming to council, has been made, has been filed with the town, or is going to be filed. If you start meeting with developers, you start meeting with communities to talk about this development, you are putting yourself into a biased position. I'm not talking you don't get to talk to the public or developers generally about general development issues. But when it comes to specific developments, where you know that that, again, has either been crystallized and solidified in an application that has been filed with the town, or you know that that is going to be coming, this is not the time to start engaging these private meetings, because this is where councillors can find themselves in a biased position and have that decision of council challenged because of the councillor's involvement in that decision-making, prior decision-making process. I've had some councillors that go to open houses hosted by developers who are advocating either on behalf of the developer or they're advocating on behalf of the community group. And I'm thinking, you have just undermined your ability to do your job, because now you can't sit and vote and debate. So, and I also just, again, going to use a wee example, and it was with the MD of Foothills, and they had a big landfill that was being proposed, a big private landfill, and it divided the community heavily. And our councillors were so plain. And it was hard. It was extremely hard, and it was very emotional for them, but they knew that either way that they decided on that rezoning, they could be challenged. And so they governed themselves accordingly, not to paint themselves with a big target. And they had views, you bet. They had lots of views, they had lots of opinions. And they came to that hearing, they had binders, and they were tabbed, and they had questions. And that's how they advocated, is they had done the research for the rezoning, but they put the questions to the experts, they put the questions to the developers, they put the questions to the community groups. And that's how they fulfilled their roles, but they kept away from the open houses and the private meetings. And so they made their decision and they denied the rezoning and they didn't get challenged. And the lawyer for the landfill group actually came up to me after the hearing and said, that was one of the cleanest hearings I've ever been to. So kudos to that council. So there's two tests for bias. Because as a councillor, you have a variety of roles. On the purely legislative side, that's just your bylaws, your noise bylaws, your traffic bylaws, etc. And in the middle is more administrative, and then on the far side is quasi-judicial. And that's where you're really weighing competing private interests. SDAB, quasi-judicial. But even when we're dealing with site-specific rezoning applications, that kind of thing, that is closer to that quasi-judicial side of things, because you are bringing some policy considerations, but you really are weighing competing private interests typically on those site-specific applications. So this closed mind test, that's really on the legislative or administrative side of things. And really, the courts have said councillors have strong opinions on things. That's why they're councillors, and they need to come to the table with their opinions. But you have to be capable of persuasion. Your mind must be open a crack to the other side of the coin. So a closed mind as a member of council will not be disqualified by reason of bias unless he or she has prejudged the matter to be decided to the extent of no longer being capable of persuasion. The beauty of that test is it's really hard to meet without the councillor participation. And typically how councillors participate in proving closed mind are statements that they make to the media or statements that they make on their websites and blogs. I had a councillor vote against the casino ones. And right before he went into the vote, said, I think this is very detrimental to family values. I'm never going to support this kind of development. Yes. The other one is this reasonable apprehension of bias. And this is the test that's going to be applied when you're closer to the quasi-judicial end of the scale. Again, site-specific applications, SDAV. And that is not as high a standard to meet. So would an informed person viewing the matter realistically and practically and having thought the matter through conclude, would he think that it was more likely than not that Mr. X, whether consciously or unconsciously, would not decide fairly? So again, this is more, it's a lower standard, but again, it's, like I said, with a counselor who was the realtor and also the SDAV board member, we weren't going to beat this test. But again, very fact specific. So if you've got any sort of question, this is something that you may want to get legal advice on. And also, within the conduct on council and within a hearing, be just mindful of inappropriate comments or behavior. That can also be used as evidence to indicate that the councilor is simply not listening or has completely prejudged the matter. And I used to be represented by Alderman Hodges in Calgary. And Dale Hodges, from time to time, in a meeting when he was done listening to you, would fold his arms and turn his chair around. Yeah. That gave the distinct impression that he wasn't prepared to hear the argument. So, you know, avoid any of that kind of conduct. I mean, even if you just think that this person talking to you is singing off some fanciful song sheet, I mean, just don't say anything. Or if you've got some good questions, ask the good questions, but avoid getting into a big argument or debate or rolling the eyes. Or I've seen some pretty good theatrics come from the other side of a council table. Avoid doing it because again, it can be used against you. So if you do find, and again, so we have this common law bias, but it's not pecuniary interest, and the Act only deals with pecuniary interest. So what do? Because you could possibly face a disqualification motion if you don't vote on something unless you're required or permitted to abstain. So what the heck do you do? If you know that something's coming in front of you, that you're going to have a common law bias, it's your brother, it's your sister, it's your best friend, whatever, you know where that is, you know what's on the agenda, you excuse yourself. You're just not there. That's the only way to handle it because the Act doesn't provide for that. But it is still something that can be subject to a court challenge. It's the only practical way to handle it. So under Section 172, this is only when you have a pecuniary interest. You have to disclose the general nature. It doesn't have to be specific, but I've got a land interest. It's just a general interest prior to any discussion of the matter. Abstain, obviously, from voting on any question. But if you have a right to be heard, you're a landowner, you're a taxpayer, you're an elector, you have a right to be heard, you take yourself out of your councillor chair, you come into the gallery and you speak. And there's no requirement that you speak and leave in the Act. However, from a perception perspective, I think it's cleaner for the councillor to speak early, say his or her piece, and then leave. Then you have no argument that even from your gallery chair that you're trying to influence council or you're trying to intimidate or influence other members of the public.
Well, just on the bias issue, did you say excuse yourself from the discussion surrounding the issue, or excuse yourself from the whole meeting?
If you know that matter is coming up, I would just be at least absent for that. I've got an appointment.
So lie.
I have to be somewhere else. Again, I mean.
For that, but you're just talking about that for that. As long as you get out of that.
That's exactly right. I mean, just, just let the mayor know. Say, you're going to be chairing, just so you know, I've got a common law bias here. It involves this issue. I'm going to be excusing myself, and that this being handled smoothly. So again, unless you're permitted to be in the room because you're a taxpayer, elector, property owner, you have a right to be heard, you're also required to leave the room in which the meeting is being held. So disqualification. The ways to be disqualified are set out in section 174. And there's a whole host of them. Breach of pecuniary interest is probably the biggest one, but also if a councillor was not eligible or ceases to be eligible for nomination under the Local Authorities Elections Act. I've had some rural councillors, I don't know what they think, but they move into town halfway through the term. Well, if you moved into town, you're no longer eligible. And again, if you're absent from all regular meetings during a period of 8 consecutive weeks, unless council's passed a resolution prior to that in time. I think you got bigger fish to fry. You're convicted of an offense punishable by imprisonment for 5 or more years. And if you become a judge or MLA or MP, decide to go and pursue provincial or federal politics, you're also ineligible. And again, if you don't vote unless you're permitted or required to abstain, and if you violate the requirements under section 172, these are all reasons to be disqualified. Oh, we got 249. If you become liable to a municipality under section 249, it means that you've breached the expenditure rules under Part 8, and again, you've got bigger problems, so we'll talk about that. So here's how disqualification. Sometimes councillors become disqualified and no one ever raises the issue, and so they just carry on. Now, under section 175, a councillor who's disqualified must resign immediately. I've never heard of a councillor who becomes disqualified and resigns immediately. Typically, when we've reached a disqualification situation, the only time that a councillor is removed is because someone's taken a run at them in the courts. Council may bring the application, but is not obligated to. And typically, it's only been in extreme, egregious situations where I've had a council try and remove one of its councillors simply because that individual just, typically it's just persistent breach of pecuniary interest provisions. But an elector may also take a run at the councillor to have him removed or her removed. Now, one interesting thing under the disqualification provisions is once the court hears a disqualification application, they have some latitude in what they do under section 176. And again, I'm going to tell you a little story. Some years ago, and this is all in court documents, I'm not speaking out of school, it was in the entry of process pass, and it was a counselor by the name of John Prince. And so Mr. Prince had a wife, and she rented a booth in their farmer's market in a hall, and she owed rent to the municipality. And so the issue of her debt came to council. I think it was like $350. And everybody told Councillor Prince, this is about your wife's debt owing to the municipality, you must remove yourself from this discussion. Not only did he refuse to remove himself from the discussion, he advocated for his wife. And they had a tape recording of the meeting, and he was yelling, and he was using profanities, and he was absolutely off the hook. So there's been a history. So council decided, that's it. We're done. We're going to go and bring this application to have John Prince removed from council because this is ridiculous. And it was an election year. And so I ran that application down in Lethbridge, and it was in front of a justice named Justice Hembrough. And I don't know if any of you know Justice Hembrough. He was a counselor back in the day when God was a boy with the city of Lethbridge. And there's extremely different legislation. And I recall him telling me, young lady, I don't need to be lectured on the Municipal Government Act. I did because I didn't understand the new provisions. But anyway. We played the tape. We brought the evidence. And then finally, 2 weeks later, Justice Hembrock issues the written decision. I don't know, it's like 12 pages. And I'm reading it, and it's great. And he's finding how John Prince was offside here and offside there, and what he should have done and what he didn't do. And I think, this is wonderful. And it came to the end, and he said, but because of my discretion under Section 176, it's an election year. Let the electors deal with them. So it was a very hollow non-victory. But there is discretion again with the justice under Section 176, where they can find that you're all kinds of offside, but still not good job counsel. So let's talk about personal liability. We talked about it briefly. Now, before I move off, any more questions about pecuniary interest, disqualification, common law bias? Okay.
Are we going to make it by 8:30?
Oh, absolutely.
Okay.
I'll just stop talking.
The RCMP officer's still here too,
Are they?
so I don't know if they.
Let me go chat.
So under Section 535, counselors are not liable for loss or damage caused by anything said or done or admitted to be done in good faith in the performance or intended performance of the functions, duties, or powers under the MGA or under other enactment. Just because this provides that you're not liable doesn't mean you can't be sued. You can still be named, and then it will be up to defense counsel to bring a motion under Section 535 to get the action dismissed against you because of this protection. But again, this isn't going to apply if the cause of action is defamation. And again, it is a precursor to this protection that you're acting in good faith. And as we talked about, if you are offside statutory provisions, I don't think Section 535 is going to help you. So there are some sections that you need to be mindful of because these are where you can be personally liable. You have a business revitalization zone board here? No?
We have a revitalization board, but
Oh, well, be mindful of Section 52. And again, it's very similar provisions to the municipalities' expenditure rules. Expenditures must fall within the approved budget. And this is also language that you're going to see throughout, is that, in this case, board members are jointly and severally liable if they approve illegal expenditures. Jointly and severally means that if 5 people voted for the illegal expenditure and only one of them has money, they can only, you might all be guilty, but they're going to recover the funds from that person that has the money. So just be mindful of that. And again, as we talked about, if you're disqualified because of improper use of information to gain a pecuniary benefit, you may be ordered to pay damages as determined by the court, which is typically a restitution of the profit that you made. Part 8, that's your financial administration. Read through Part 8. If you do nothing else, read through Part 8 and be mindful of what your obligations are. Section 249 provides for the personal liability for individual counselors. So a counselor who makes an expenditure that's not authorized under Section 248, or if you vote to spend money that's been obtained on a borrowing or a grant on something that was not within the purpose of that borrowing or grant, you can be personally liable. But again, it's only if you vote. So if you've got a bunch of counselors and you're thinking, what are you guys doing? We cannot spend, we cannot authorize this expenditure because of our obligation under the Act. Ask for a recorded vote, because then it's clear who voted against that motion to make that expenditure. And if you voted against it, you're not going to be at risk of being personally liable. And again, under 249, counselors are jointly and severally liable, which means it's not necessarily going to be an equal compensation number for each one of the counselors that voted in for. You can also be personally liable under Section 275 if you make a borrowing, loan, or guarantee that causes the municipality to exceed your debt limit. But again, You're only going to be liable if you voted for that bylaw authorizing the borrowing loan or guarantee. The only other out is if the minister approves the borrowing loan or guarantee. And I mean, that's easy. You just know what your debt limits are and where this puts you. And personal liability may be enforced by the municipality, an elector or ratepayer of the municipality, or a person who holds a security under a borrowing made by the municipality. And there's a case out of the MD of Bighorn with Sam Hall. And I don't know, do any of you remember that case? I know you do. So this involved basically investments that were outside of the parameters of Part 8. And there was a big fraud charge. Their chief financial officer went to jail. He was involved in the scheme. It was multi-million-dollar. And originally with that lawsuit, the councillors that also voted in favor of these fraudulent investments, everyone just had bad information, but nobody asked for confirming information. Anyway, these councillors were all named personally. They got dropped from the action in their personal capacity before it hit trial. So all that was left really was their CAO to take the fat.
Oh, God.
Anyway, but the Court of Appeal made some interesting commentary about councillors that I think is very mindful. As they said, you're in a position of trust. You're a trustee of public funds. So that is a level of responsibility that the court will impose on councillors when you're dealing with expenditures. Now, unfortunately, with the CAO, he got tagged for the full amount, and 535 didn't save him because it was outside of the requirements of Part 8. The other lesson learned is if you have got questions, well, questions frankly on anything that comes before you in council, but especially with respect to financial matters, ask the questions and keep asking the questions until you understand. And don't worry about seeming, this is a stupid question, I'm going to seem like I'm not sophisticated. If you don't understand, ask until you do understand. And if the report, even if you've got a consulting report or a legal opinion or something from the auditors that you don't understand, get clarification. And if you can't get clarification, you get another party to review the matter and give you a report. That's how important it is. And that's really what happened with that investment is they were given reports that were all correct. And there was a bunch of questions, but no one wanted to look stupid. So no one asked the hard questions to try and get the clarification. So again, to-do lists, unauthorized expenditure policies, which I think you have in place. And again, before authorizing any borrowing, lending, or guarantee, know what your limit is. And again, if you disagree with a motion, ask for a recorded vote, especially when we're dealing with these personal liability matters. Okay, very briefly, we're going to talk about the Freedom of Information Protection of Privacy Act, because you need to be mindful that the definition of records extends to your stuff. It extends to your phones. It extends to your computers. Anything that you are conducting municipal business on is going to be subject to disclosure. And again, not speaking at a school, this was with the Rocky View councillors in that recent lawsuit that Rocky View prevailed with. But all the councillors are subject to FOIA requests, and they all had to go through their phones and their computers and find emails and that kind of thing. So be careful what you have out there, because it can be subject to disclosure requirements. So again, a couple mandatory ones, anything that would reveal that is protected from disclosure, confidential trade secrets, business information, personal information, that is mandatory confidential and not subject to be disclosed under FOIA. But then there's a whole list of things that may be exempt. And again, this is really relevant to council when you're deciding, do we go in camera to talk about this or not? Because the only time you can go in camera is if we're dealing with FOIA matters. Law enforcement, intergovernmental relations, draft resolutions, bylaws, contracts, that kind of thing. You've got draft advice, proposals, recommendations, that kind of thing. It can be discussed in camera. Obviously, when things are finalized, you want to adopt a report, you want to take action, you're going to bring that into a public meeting. Matters which could be harmful to economic interests of the municipality. anything to do with solicitor-client privilege or getting legal advice on anything. And if you've got information that's going to be available within 60 days, that's also not subject to disclosure. And very briefly, with respect to environmentally sensitive lands, I only raise it. I don't know how much really it impacts Strathmore, but I know you've got some wetlands. But these cases really stand for the proposition that where a municipality is aware of specific site hazards or risks with respect to development, you've got the obligation to get the information that you need to properly assess those risks and either deny the development or set the appropriate conditions for the development to mitigate against those risks, or you could find yourself in a liable situation. We have a situation, obviously you weren't impacted by the floods, but we've got situations now where we've got municipalities facing development in new flood areas. And they are really, councils really wrestling with these obligations because the rules have changed with flooding, frankly. Off-site levies, it's in my materials, so I'm not going to bore you to death with the details, but I want just to be clear with you with respect to what the rules are on off-site levies, because I've seen, and not with respect to Strathmore, but I've seen in papers generally with people running for different councils where they are very critical of the restrictions on off-site levies that are imposed by the municipalities. Well, Calgary gets them for fire halls and schools and art and all this other jazz. Why the heck aren't we doing it? We're being too soft on developers. But two things. Calgary does all kinds of things that aren't necessarily within the confines of the Municipal Government Act. They just do. Calgary has deals with UDI that no other municipality has, which means that developers don't challenge Calgary. That's the way it is. If smaller municipalities tried to impose unilaterally some of these fees that Calgary can collect, you are likely to run into a court challenge. And it was Prairie Communities and Okotoks. And what this was is Okotoks impose a whole list of additional recreation levies, library charges, all these soft services that are outside of the parameters of Part 17. And again, as I said earlier, relied on their natural person powers to do it. The Court of Appeal said this was not a voluntary agreement because it's a condition of them getting their development permits. So you can't be arguing that they voluntarily entered into these deals. No, they didn't. If you wanted to develop, that's what you ponied up. They also said you cannot, municipality, go outside the parameters of Part 17. So you're limited right now until there's a change in the legislation getting off-site levies for hard infrastructure, water, sewer, storm sewer, roads. It's the way it is. And the other thing that's important from Prairie Communities to be mindful of is the old rule, well, developer just pays. If there's infrastructure to be built, that's it, 100% to developer. That's not the case. The Court of Appeal has said through the Prairie Communities decision with the Okotoks, Cochrane decision with UDI and Leduc County, is there has to be a cost-benefit analysis done between allocation of this infrastructure costs between existing and new development. So again, just be mindful that the old attitude, the developer just shoulders 100% of any new infrastructure costs isn't necessarily the case unless you and the engineers especially have performed that analysis of will this benefit existing development? Because if it benefits existing development, then there's got to be that apportionment, whether it's 5%, 10%, 20%, and the developer pays the rest. So that's the change in rules that came down with this Okotoks decision. So if you're wondering, well, why the heck isn't developers paying 100%? It's because of rules change in the Court of Appeal. And again, Alberta Land Stewardship Act, and I'm sure your staff's going to bring you up to speed with respect to the South Saskatchewan Regional Plan. The draft was released last week, and there's further workshops and stakeholder consultations going through November. When I read this, what was really going to impact your life that much? Your bigger one's going to be the Calgary Metropolitan Plan, and that's really probably going to be, I'm guessing, as a sub-regional plan.
Yep.
Is that what our thoughts are? So that's really going to be the bigger issue, I think, for Strathmore. And your staff's going to bring you up to speed on that. So look at that, Joy. 10 minutes to spare.
Wow.
So do you have any questions? Anything that I haven't covered or clarification on things that I did?
But if we do have questions in the future, we can give you a call.
Absolutely.
Okay, that was good, thank you.
Okay, thank you so much.
Thank you. Thank you. Adjourn
Oh,
meeting?
my only other point, and I apologize, I meant to say this. The other way that I found sometimes the councils can get the municipality into the muck is if you are putting things out for tender and you happen to know some of the contractors that might be bidding, don't talk to them about the project. Because as soon as you start giving any contractor special information, you're in violation of the rules. Okay, thank you.
Yes.
Your worship, this isn't in regards to Joanne, but just before we conclude tonight, as I watched our young members of Strathmore Assembly of Youth leaving, it occurred to me that we miss them in our committees. And I don't know if we want to deal with this tonight.
And you sit on that one, and I told them that I would come over and visit too, so. So, seeing as we've...
I don't know if we want to do that tonight or...
Yeah, okay. So, do we open that back up? How do we handle that?
Just be new motion.
Yeah.
Okay. So, did you want to make a motion on that, Bob?
Well, first of all, I would like to see if anyone else wants to sit on there. I have sat on there for a couple of years, and I do have new committees now, and I wouldn't mind maybe giving someone else the opportunity if they so desire.
I think it's on the same Wednesday evening that the CAO meetings are held, and it's right after school. That's when
Yes,
they hold that, I think.
4 p.m. on the second Wednesday of each month, traditionally.
Then I'll sit on it.
We're looking for volunteers.
So,
Well, I'm at the high school anyway, so I don't mind sitting on that one. I'll just stay for it at that day.
so motion was moved that
I would move that Councillor Field and Mayor L sit on the say committee.
discussion? None? All in favor? And
Move to adjourn.
entertain a motion to adjourn. I don't think we have to discuss it.
So move.
Thank you. Adjourn. Thank you very much.